It's a panel interview. My name is Stubbs. I'm an attorney in town, and I am moderating. As a moderator, I don't vote. I will keep time. I will direct the discussions and the interview questions. If you are over time, I will stop you. I'll do it politely at first, and then if you won't stop, then I'll talk over you so that they can't hear what you're saying anyway. We just ask that you please respect the process and respect the rules, and that everybody has the same amount of time, and to keep this what is intended to be. As a first order of business, all candidates here were actually notified by email on January 22nd of this event. And they were told that February 14th was the deadline. They also all received a follow-up phone call from Steve Stanson on February 10th. The candidates that are seated today responded timely. There was one candidate that was 5 days late. So pursuant to the rules, what we need to do is we need to have a vote by the panel to decide if he gets to participate or not participate. And that's Mr. William or Bill, is it Skupa? Mr. Skupa. So all in favor of having him participate, please raise your hand.
Stephen, we don't vote, but I want just...
Okay, thank you. And those opposed. Okay, Mr. Skupa, please take a seat. We simply want to obey all the rules and everything that we've done in the past. The format of this panel interview is as follows. There will be a 1.5 minute introduction where every candidate will be given 1.5 minutes to tell us about yourself and your qualifications and anything that you really want to say. This is your time. I will say that past military experience and experience with the Constitution, that does weigh heavily with the panel, as in the past. That's my only advice to all of you. Afterwards, excuse me. Excuse me. Before we start, George Shahade will offer an invocation.
Let us stand, please. Let's bow our heads. Dear God, we come to you this beautiful day, beautiful morning. Thank you for this location that we can have with a view. Thank you for Rhythm Kitchen allowing us to meet here today. Father, we pray that you bless the proceedings this whole day, that your will be done in all these things. Bless all the candidates, those that are doing the interviewing. May they ask wise questions. And Lord, we ultimately ask that you put people in office that do revere you and revere the history of America, that it is a God-fearing country, and we pray that it would stay that way. We also cannot overlook the fact that our freedom and our sacrifices have been made by the sacrifices of the military, of the veterans, both past, present, and future. We pray today that you would bless them all, wherever they're at in the world, that you would guide them and direct them and encourage them as they are in harm's way for us and our freedom. We pray in Christ's name, amen.
Amen. Is there a flag? Is there a flag? Is there a flag? No. Generally, we do a Pledge of Allegiance as well. However, there's no flag, so we will not do the Pledge of Allegiance. So the format of the panel discussion is as follows. Each one of you will have a 1.5 minute introduction. Then each panelist will get to do a 30-second question that is either specifically directed at each candidate at a time or to the candidates in general. You are then given 1 minute to answer, and only 1 minute. There will be no follow-up questions by the panelists. They're responsible for their questions, and you're responsible for your answers. However, we do not want any personal attacks or negative things said about other candidates. That's something that will count against you. This is a panel interview, not a debate. So please respect that. If anything negative is said about another candidate, that candidate, at my discretion, will be given the opportunity to respond. But we'd ask that you just simply keep this clean. This is an interview, like a job interview, so please do not partake in that. So if everybody's ready, we will begin. Mr. Skupa, would you mind starting with your introduction? And just allow me to get my timepiece ready.
Hi, my name is Bill Skupa, as you heard. I appreciate you letting me participate in this. I apologize for not responding in a timely manner. I've been in Nevada since I was 3 years old. My wife was born here. My 3 children were born and raised here. I went to school. I graduated from basic high school, graduated from Nevada Southern University, that's now UNLV. They didn't have a law school here, so I went to UCLA. But practiced law here for about 43 years. I've done pretty much every kind of law there is. Practiced from everything from business law to divorce law. The last several years I've focused mostly on personal injury and criminal law. I've community activities. I've participated in coaching boys baseball, girls softball and soccer, boys basketball. So I've done all of those things when my children were younger. My children were all born and educated here. My father was a casino dealer. My mother stayed home most of the time until he died when I was 18, and then she went to work in the county assessor's office for about 20 years. Retired from there. I've been a businessman in my own law practice for these 43 years. Approximately, I started out as a prosecutor in the Clark County District Attorney's Office and moved into private practice.
Thank you, Mr. Skupa. Thank you very much. Next will be Mr. Scotti. Your time will start as soon as you start.
Well, good morning, everybody. It's a great honor to be here. Veterans in Politics is an organization I have tremendous respect for. My name is Richard Scotti, and I'm running for District Court Judge, Department 2. I'm the candidate that I believe I have the most diverse and substantial experience. I've been practicing law for 26 years in the areas of general business and construction and general civil litigation. I've served for many, many times as a mediator, an arbitrator, a Supreme Court appointed settlement judge, and an administrative law judge. And for those reasons, I have extensive qualifications to conduct hearings and to resolve disputes. I've been very active in my community. For instance, I've taken on several cases with the Legal Aid Center of Southern Nevada, as well as a few years ago I donated $2,500 towards the development of their new building. I've been a strong supporter of this organization, having contributed a lot of time and money over the years. I'm a 2-term member of the Nevada State Bar Board of Governors, so I have the respect of my peers. I'm A-rated, so I have the highest rating in professional responsibility and legal ethics. I know that veterans deserve and need a fair shake. I'm going to fight for veterans' rights to the full extent of my ability. I've done that already on the State Bar Board of Governors, fighting for the Veterans Court. You can see all the things that I've done for this organization in the handout I've provided to you. I respect veterans. I know that veterans deserve more, as my dad and my brother are Marines, and I would appreciate your support. Thank you.
Thank you very much.
Hello, my name is John G. Watkins, born in St. Louis, Missouri, married 45 years, 4 children. My youngest is now 21, has Down syndrome. Spent a lot of time with that particular organization. I've been practicing law here in the state of Nevada for 34 years. Have, as Mr. Skupa, vast experience in both civil and criminal. I used to be a deputy district attorney, worked with Judge Pavlikowski as a law clerk, and have been in private practice ever since. My military experience happens to be, I was appointed by Governor Miller in 1989 for the Nevada National Guard Reserve. I went in as a captain, as their legal officer, was promoted at one point to a battalion commander, and was also promoted to the state commander of the Nevada National Guard Reserve. I left that organization after 11 years. I was appointed the employer support for the Guard and Reserve. Very important position. I'm sure you're all familiar with that, and I took an active role. You all know that that's a volunteer position. I helped a lot of the soldiers get their due because some of the employers don't seem to respect the veterans. So rather than talk about it, I actually participated and have the military background. I appreciate your support. I intend, I want to be a judge after 34 years, and the experience I have, by the way, I've handled over 100,000 cases and never had an ethical complaint against me, and I take great pride in that. Thank you very much, Steve.
Very much. Next will be Ms. Phung Jefferson.
Good morning. My name is Phung Jefferson. I thank you guys for inviting me here. I apologize for being late. I was actually participating on a radio station giving information on the community. My background is I moved here in 1982 when my father was transferred here to Nellis Air Force Base. He's a 26-year veteran of the United States Air Force. I was born in Vietnam. My father met my mother in Vietnam and brought me to the United States and adopted me. My practice, I have a private practice which I started in 2003. I do family law, civil law, criminal law. I have a general practice. I have given back to the community in various ways, one of which was going and arguing a case before the Nevada Supreme Court pro bono for a father who did not have the means to take his case to the Supreme Court. I'm looking forward to participating in your questions. Thank you.
Thank you. We'll now go to our panel interviews, and we'll start the first question with panelist Ms. Karen Steelman.
I'd like to pass, please.
Okay, to Ms. Kim Bosley, and again, there's 30 seconds for question and up to 1 minute for the answer. Ms. Bosley.
Okay, this question. Good morning. This question is directed to Mr. Scotti. You stated that as a mediator and an arbitrator in cases involving significant issues, money, that you demonstrated the temperament and knowledge. How have you demonstrated that temperament?
I demonstrated my temperament by being a good listener, showing respect to all the participants that have appeared before me. I'm never rude. I don't use slang. I don't yell or raise my voice. I think that it's the ability to convey the law in a polite, professional, calm manner that helps. So that's been the most effective way in helping parties to mediate their disputes. In arbitration proceedings, I've felt that the best way to achieve result in an arbitration proceedings is to ensure that you have due process, because with proper due process, the participants feel that they're getting a fair shake, and even if they are not receiving the decision, they come out of the courtroom feeling that they received a fair shake, and that's the most important thing is due process.
Did you have any other questions for any of the other candidates?
I guess this question can be directed to the other candidates as well. How do you demonstrate temperament?
Can we start with, generally what we do is we move down the line, and we did start introductions with Mr. Skupa, and then now Mr. Scotti. So Mr. Mr. Watkins, would you please answer that question?
And the question is my temperament?
Right.
Well, I've been known in the past to vigorously represent my clients within the bounds of the law. I've been known to raise my voice. I do cuss on occasion, cuss more than I should. I'm a warrior. I'm not, and I don't like bullies, and I will fight. As a judge, most importantly, I'm very courteous to everyone, from the porter at the courthouse all the way to the Supreme Court justices. And I kind of sometimes like those people down there better than some of these up there. So, as a judge, you have a temperament to make sure that you have a level playing field, courteous to your people, and be prepared. And I'm judge, and I'm going to be the judge. They better be prepared when they come into the courtroom, because I'm prepared. I've worked hard for 34 years, Saturdays, Sundays, no slack time. but I cuss a little too much, but I won't cuss here. I'm trying to make an impression.
Thank you very much.
Thank you.
Ms. Jefferson.
I agree with Mr. Watkins. There's a time and a place for everything. The type of clients that we have within the criminal system, just sometimes you have to cuss, and I do that too. However, in the judge's role, your temperament has to be that of understanding most of all. I believe that the people who come in front of you definitely need to know that they're being heard, whether it's a good position or a bad position. I've gotten that through being a small claims judge. In a small claims court, if you don't know, that is the people's court. You rarely see attorneys in that court. And in my experience, it's even though when I'm making a ruling against somebody, the fact that I acknowledged that I heard their side of the story and acknowledged what they were going through meant a lot, even though I did rule against them. Because a lot of times when they come in, they know that they have a bad position. It's just they had to get something off of their chest. Also, my experience within the family court arena, because I've done that for over 20 years as an attorney and as a paralegal and as a
Time.
secretary.
Thank you very much. Mr. Skupa?
One thing I neglected to mention when I was first giving my introduction, I've been a arbitrator and mediator, and I have been a judge pro tem in district court, which is a short trial judge. We have short one-day jury trials, and they started that in 2002. I've been a short trial judge all during that time, so I've actually been doing the job that I'm running for now as a short trial judge. And in those short trials, I've tried cases before juries and without juries, and I've always treated the witnesses respectfully, been courteous to everyone, and the litigants and their attorneys, and I believe in that. I've always tried to be fair and impartial. That's the role of the judge, and apply the law to the facts. You know, I've never lost my temper in a case where I was the judge or an arbitrator or mediator. Sometimes when you're on one side or the other, you can, you know, get a little more fired
Time.
up, like John says. But
Thank you very much. Thank you, Ms. Boston. Ms. Cheryl Gardner.
Good morning. In full disclosure to the panel, none of whom I know, I am a certified court reporter for the state of Nevada. I've been here in Nevada 28 years, and I've had the pleasure of working with Mr. Watkins and Mr. Skupa, who I watched vigorously defend their clients. So just so you know, I do know them personally. My question for Mr. Skupa is, why now? Why did you decide now to run for judge?
well, primarily because I've been the short trial judge for about 12 years, and I like that. I like being in the courtroom. I go to court pretty much every day during my practice. And you know, sitting around the office just isn't my thing. That's why I've done mostly personal injury law and criminal law, because you get to go to court. And I like being in court. I like deciding legal issues. I've found that that's a good way to make sure that everything is fairly done if I'm the judge. And I think I can do that. I think I can apply the law as I have every time I've been a judge or an arbitrator. And of course, the mediator, you try to get cases settled. So I've done all of those things, and I just thought it was a kind of a natural transition after all these years to make that transition. Thank you.
Thank you. And Mr. Watkins, you have really made a name for yourself defending people with DUIs. So how would you feel in a civil venue as opposed to working with the misdemeanor DUIs?
Well, first off, Cheryl, you probably don't know, but I have an extensive history in civil law. Back through law school, I took no criminal cases, no law in criminal law. I have done personal injury, I have done welfare, I have done wills and probates, divorces. There's nothing in the civil arena that I haven't handled. I'm known as kind of the DUI guy with the Jessica Williams case more particularly. I'm a vigorous advocate, and I was also a vigorous prosecutor when I was working with the district attorney's office. So I'm certainly able to handle the civil as well as the criminal, and again, they must be prepared because John Watkins is always prepared.
Thank you, sir.
And thank you.
Hey,
No
Ms.
tough
Gardner-
questions.
Ms. Gardner, is there any question you'd like to direct at Mr. Scotti or Ms.?
I can't think of anything right now, thank you.
And if you could turn your name tag so that I can pronounce your name correctly, I'd appreciate it. Thank you. And how do you pronounce your last name?
Dupre.
Dupre. Okay. So Ms. Danielle Dupre.
This is a question for all the candidates. The general public has a problem with the judicial legal system. They don't see it in a very good light. What are you going to do to improve that perception?
And we will actually start with Ms. Jefferson on this one.
I think the first, hello? Yeah, I think the first thing that needs to be done is making sure that we are accessible. The courtroom is a public forum where anybody can actually come in and observe court proceedings, but also being available to the public by going into the public to interact with the public so they can ask those questions that we can answer and give them a better feeling with dealing with the judiciary. Because right now, I think the public sees the judges as people that you can't touch. And in actuality, we are part of the community, and we are elected in by the community. I think one of the bigger things is that the community needs to participate in the election process and get to know us when they're electing us into the position. And so it's really hard to say that we, as a judiciary, when we get on the bench, we can make the change. The public has to get involved also, and get involved before we get on the bench, because they actually make the decision, so we're there.
Thank you.
Sorry.
And Mr. Skupa?
We're playing a musical microphone.
It goes down the line. Let's try to keep it consistent.
I have to agree with Ms. Jefferson that I think accessibility is important. You know, I would be available to talk to anybody about a case that I wasn't participating in. Obviously, you can't discuss those. But the perception is tough to overcome because you have to apply the law and rule in each case, apply the law correctly to the facts. And sometimes when it comes out in the newspaper, the newspaper or the person reporting has a slant on it. So that may skew the public's perception of what goes on in the courtroom. But for the most part, when I've been in court, the courts run very well and the judges are very fair. And again, like John Watkins, my colleague, says, you know, you have to be prepared to rule correctly on the law, because that's where cases get overturned on appeal.
Time. Thank you very
If you
much.
don't rule correctly as a judge.
Thank you. Mr. Scott.
Thank you. And an excellent question. And the question is dealing with public perception. And there's two aspects to that. There's professionalism and civility. And I've worked extensively in both of those areas in my 22 years here in Clark County. I started my practice working on the Professionalism and Community Service Committee, developing the Lawyer's Pledge of Professionalism here and promoting that Pledge of Professionalism. And in my practice the last few years, I've been handing out a nice copy of that Pledge of Professionalism to all new attorneys. Moreover, the State Bar President has appointed me to be the chairman of the Civility Task Force. And on that task force, we've been investigating how lawyers can be more civil, both to the court, to other lawyers, to clients, and to all persons that they come in contact with. And a part of that committee, what we've done is we've drafted a resolution that's gone up to the Supreme Court to change the attorney's oath that requires us to be more mindful of those civility obligations. And that's what I've been working hard to do.
Thank you very much. Mr. Watkins.
I'm here not to blow smoke up anybody. The public perception of judges and lawyers is not going to change much. We rank below used car salesmen in public opinion. What I would do is what I did in the Jessica Williams case. I was very professional, and God was very kind to make me look like I knew what I was doing. I had a tough case to deal with, and I dealt with it to the best of my ability. And I think that that's the only thing that a judge can do. And when someone sees that type of performance, that caring, there will be, hopefully, at least to some, that, you will get a fair shake in court. But in all honesty, ain't gonna change public opinion. Lawyers they don't like, and if you got a case and your opponent's against you and the judge rules for your opponent, you ain't gonna like the judge. Let's be honest, we're people. So this is not a blow smoke time, this is a real John Watkins, okay? Thank you.
And Ms. Jefferson.
I answered the question first.
Oh,
Do it again.
Ditto.
Yeah. There you go.
thank you. Mr. Jason Brooks.
Uh-oh. Serious.
I could just use my Marine voice if you want me to, but I prefer to use the microphone, if that's okay.
Now let's hand out handouts. Here's the.
Don't want to scare everybody here.
They're gonna think you're a lawyer trying to take the show.
Oh, I don't think my opinion's that low, I think. Joking, I'm joking, I'm joking. Good afternoon, Good afternoon, candidates. I appreciate you showing up to the panel today. Being a 100% disabled combat veteran, born and raised here in Las Vegas, I've seen a lot of issues come up here for veterans. Fortunately, we have Veterans Politics and Steve Sanson to help out with a lot of these things. As you all know, Governor Gibbons signed into law the Veterans Court system. It's referred to as a specialty court. There are a few dozen specialty courts here in the Valley, and a lot of people were talking bad about having a specialty court for veterans, because why should we be treated better than anybody else? So I've got a couple questions for each of you in reference to veterans courts. First question for each of you is, when someone is going to come into your courtroom, will you have your bailiff and or yourself first verify to find out if this person is indeed a veteran that qualifies for a veterans court program so they can actually get into veterans court?
My answer is yes.
Can we start with Mr. Skupa?
Passing the microphone, please.
Of course I would do that, but I would think there are procedures in place now to determine whether people are veterans to get into veterans court. You would have to verify that they're veterans before you let them in. I mean, you can't just let anybody walk in there, and I think veterans court is an excellent idea, as are most of the other specialty courts. They deserve special consideration because of their service to our country. Thank you.
Mr. Scotti.
Yes, absolutely. I will ask my bailiff to let us know. And more than that, I'm going to post an announcement somewhere in the courtroom that's quite visible to let all the veterans know, to make sure that they speak out in case they're not asked first.
First off, you don't ask the bailiff to do anything, he ain't going to be able to answer that question. So the judge would have means to certainly find out. And there's coordinators. I use the program for my DUI people. I have a lot of veterans that I've been able to avoid the harsh punishment of DUIs because they were combat veterans, etc. People don't understand, just because you drink and drive doesn't mean you're a bad person. And some people have had some real problems. And when you're a soldier and you are in combat, or just being a soldier, you can have some problems in the courts. I've always been compassionate, and I would continue to do so. But I'm not going to ask the bailiff, because he ain't going to know how to do anything except protect you.
And you.
And I agree with Mr. Watkins. The bailiff's there, he has a different purpose. The first line of defense for that is the person's attorney. The attorney has the duty to sit there and advocate for their client. They should be asking that question. But in the district court, the crimes in that court are more egregious, to say, under the law. And so a lot of the times before sentencing, they go to PMP. So I really think that there's other levels where that information can be found out. However, if I have a suspicion based upon some of the information that comes into me from the attorney or even the DA or whoever, then yes, I think I need to ask that. But the number of cases that come through the court system, I don't think that that's a feasible thing for a judge to ask every defendant who comes in there. But I think that there's other agencies that should be asking that question because of the things that the veterans have done for our country.
Is that all, Mr. Brooks?
Yeah, that'd be it for now. Thank you.
Thank you. Ms. Jordana Carroll. We'll be starting with Mr. Scotti on this question. Thank you. Unless it's directed specifically.
General question, thank you. What would you do if a case was presented to you that did not demonstrate due diligence or improper case management?
That did not demonstrate proper case management or demonstrated lack of due diligence?
Correct.
Attorneys are notoriously late on doing everything. And that's civil attorneys, criminal defense attorneys. Well, this is what Mr. Watkins was saying earlier. He knows that. What you need to do
I'm not late.
Okay. Look, you have to understand that there's life sometimes gets in the way of work, and family commitments sometimes get in the way of work, and sometimes attorneys are late. And many times the fact that an attorney is late doesn't cause any prejudice. So you really need to look at this on a case-by-case basis to see whether the administration of the case has been prejudiced, whether any of the litigants have been prejudiced by this, whether it has caused undue time or expense. I like to give a pass when it happens one time. For instance, if somebody is late in turning in documentation, I have this come up all the time with the state contractor court. Okay.
Thank you.
Thank you.
Now, if you could repeat the question, I don't believe that some panelists, heard or understood.
I'll repeat it, please.
Thank you.
What would you do if a case was presented to you that did not demonstrate due diligence or improper case management?
Thank you. And Mr. Watkins.
Mr. Watkins.
First off, it looks to me that a lack of due diligence could have an effect on the legal representation of the individual, and therefore I would be in a position to take control of that. As far as my pet peeve is lawyers lying. They quote cases that don't stand for the proposition, and I will not stand for that. They will be reported to the bar, and that is quite common. And I can tell you, I never misquote anything. And I would not tolerate that. But in answer to your question, if someone, the way you pose that question, someone hasn't been represented zealously and fairly in the law, and so we need to correct that. And that's what a judge is for. And you learn that through your 34 years experience. And then when you get on the bench, you know how to deal with that situation. Thank you very much.
Ms. Jefferson.
I like to go ahead and say that Mr. Watkins is correct, is that as a judge, you are in a position where you can have some impact on that, but at the end of the day, the person hired that attorney, and I think that the way the judge can actually impact that is being prepared for the case, because the judges get briefs. If they don't get briefs, you start asking those questions, but we have certain guidelines that we have to follow. We cannot sit there and show any preference to either side. I mean, that's just like seeing the DA in a criminal case hasn't done their case right, or they missed something and saying, hey, let me ask that question. Well, that's not right when the other, you have a defense attorney on the other side who's done all their work, and you have, basically you have, an extra DA on the other side. So I think that it's just making sure that the judge is on top of being prepared for the cases in front of them, each case that's in front of them, and making those rulings and asking the questions. Because as a judge, we get to ask those questions to sit there and bring it to everybody's attention.
Thank you. And Mr. Skupa, you get the last word. Mr. Skupa.
Well, I have a tendency to agree with what the other panelists have said. A judge does have the option. You can't represent somebody, but you can make sure that they're well represented, and if it doesn't seem fair that they've left something out, sometimes by reading the cases that the other side has cited or looking at their argument, you can tell whether they have the right position or not. And if somebody is really underrepresented through lack of diligence or improper case management, sometimes you can grant a continuance and ask them to take a look at the case again. You don't want to be unfair to anybody. The idea is to hear these cases on the merits. And you do have the power as a judge to make sure that the litigants are represented fairly. That presents a kind of a unique question because, again, you can't represent anybody. But you can even things up in certain ways to make sure that each party gets their point across.
Time. Thank you. Ms. Alicia Green.
Good morning. I want to premise my question with, I have a father that was a Vietnam War vet, so he has PTSD. My brother also went to war, he's 26 and he has PTSD as well. So I understand the perils that they face when they get into trouble, and I think there's definitely a cognitive disability that's induced by the psychological sacrifice they make being in these situations. But how do you separate concessions with accommodations? Because we still need to make sure that we are providing the proper treatment and rehabilitating these people going to the specialty courts, these veterans, and really give them an opportunity to coexist in society again, because essentially they are trained to kill. And then you come back to society and you can't inflict that type of punishment when you're faced with a situation where you may feel threatened.
And Mr. Watkins, if you could start with this.
Thank you very much. First off, there's no question that rehabilitation is what we need to do. However, let's be honest also, if someone comes back and murders people, we have to deal with that accordingly. But typically we don't see that. Okay, we see people that, we see more maybe using drugs and alcohol to medicate their problem. And I'm a firm believer in helping people as opposed to hurting. Our laws on DUIs and drug addiction are supposed to help and rehabilitate. However, I don't see that happening very often. So it boils down to being a good judge in that regard. It comes from the heart. You are what you are. If it's in here, it comes out. If it isn't, it don't. And if you have compassion for people, then you're going to be able to help some of these people. And unfortunately, if they do something really horribly bad, they have to deal with that situation.
Thank you. That's great. Ms. Jefferson.
I concur with what Mr. Watkins says. In the district court, like I said earlier, the charges are more serious. They hold higher penalties. And I agree that a lot of the issues that come back with the veterans who come in front of the court have to do with them masking their pain or their experiences with alcohol and drugs. I think that also goes in hand with the fact that they don't know where to get the resources to help get the help. And I think that's what one of the primary things that Veterans Court has done in the lower courts, in Justice Court and Municipal Court, is that as part of the process is that they are being put together with the VA benefits, and they're being directed and actually have their hand held to get to the different places that they need to get the benefits that they have, including disability, the medical care, the counseling. And so I think that some of that stuff is already in effect. I don't think it's in effect in the district court for other reasons, but I know that the state is looking to do that.
Thank you very much. Mr. Skupa.
Well, rehabilitation is always very important in the role of judge and sentencing. There are some crimes, as John says, that you just can't just deal with rehabilitation. And hopefully through the process, maybe the person has been referred to Veterans Court and maybe given some leeway and some special treatment along those lines. But you have to make the punishment fit the crime, and the person that committed the offense has to be considered, and you have to consider the danger to society as to what your sentence is. If you can rehabilitate somebody without endangering society, that's the most important. Depends on their prior record, whether this is a one-time thing, what they've done, what they've tried to do to help themselves, what is available to you as a judge to give them the assistance you think they need to stay out of this type of trouble again.
And Mr. Scotti.
Thank you, Ms. Green. The Veterans Court is doing a great job right now in trying to help rehabilitate veterans, and the program as currently constituted doesn't allow veterans that have committed violent crimes to go through the program without the consent of the prosecutor. So there is a good balance now between accommodation, as you said, and concession and rehabilitation. Look, we got a serious problem here facing our veterans. We have 15 to 30% of Nevada veterans that have PTSD. That's higher than the rate in the country. We have a suicide in Nevada of a veteran every 3 days. That's 4 times the rate in our country. We have 45,000 veterans that are being treated at the VA clinics and hospitals in this state. There's a serious problem. Our veterans need help, and I have a lot of faith and trust in our Veterans Court to help, to allow now our judges have the discretion to help these people get the treatment they need. And they have an opportunity which is available to them. And it's a one-year program. If they fail in the program, they go back with the regular system. We got to give them an opportunity.
Sir. Thank you. Okay, Miss, I hope
Romine is fine. I added law to make my husband happy at the end.
Well, then I want to make him happy too. Romine Law.
He's not here right now. Well, my disclaimer will be that I'm a lawyer, so I'm going to have the most boring question on this panel. But because it is really hotly debated, and I think this is going to be at least a mostly civil department, what is your position on the constitutionality of the coded initiative, the Keep Our Doctors in Nevada initiative that treats medical malpractice so differently than any other civil matter, with the affidavit requirements, the cap on the non-economic damages, the cap on the plaintiff's attorney's fees, not the defendant's attorney's fees, and the modification of the collateral source rule?
I think that your question goes more towards the legislative branch, because that's kind of where this started off on. I mean, as judges, we're required to uphold the law that comes through, and the initiative was voted through by the community, and so our hands are kind of tied. That's not something that we can actually change, and so that's something that needs to go through the legislative process, if I understood the question right.
Mr. Skupa.
I have to agree with Ms. Jefferson. I believe the constitutionality of all those laws has been tested. Certainly the collateral source rule we wouldn't want to see jeopardized. That's a very important rule, and there's no reason to change that from what it is. The other laws, again, whether you like them or not as a judge, you have to enforce the law and apply it as it's written. Again, it's up to the legislature to change those things, and I believe the constitutionality has been ruled upon. I'm not sure that I would have ruled on it the same way that it's been ruled, but I probably don't have that opportunity, and only the Supreme, you might as a district judge, it might come before you, and then it would wind up ultimately before the Supreme Court. So in an appropriate case, I would apply the law and see if anybody made some arguments that were legally supported to change the law if I thought it needed to be, and apply that the way I thought it should be.
Time. Thank you. Mr. Scott.
It is a difficult question because we're all going to be on the bench, or one of us is going to be on the bench ruling on personal injury cases. And it really is a policy question. And the law is pretty settled on collateral source rule and the caps and the affidavit requirements. Generally, all of those elements of the law tend to restrict choice, though. They tend to restrict an injured party's options. I recognize that we need to provide, if there's a way our legislature can ensure that our injured persons are going to have better choices of lawyers, more choices of lawyers, more opportunities to vigorously pursue their cases, let these cases get in the hands of the jury. That's what I'm more in favor of. And I would advocate that our legislature tries to accomplish that. Let our jurors decide whether an attorney should recover his attorney's fees, whether there should be punitive damages allowed. And personally, I'm against the cap, but it's a legislative matter, and I would defer to our legislators.
Mr. Watkins.
First off, running for judge, we're not in a position to give our opinion as to, on the particular issue. However, there's no question, it's a good question, because on the one side, are we going to allow doctors to somehow say, hey, look, if you don't do certain things, we're going to leave town? And we certainly, as human beings, don't want doctors to leave town. On the other side of it, you don't want to be held hostage either. Being an attorney, you know what malpractice costs. It costs a lot of money. I pay it too. Okay? Unfortunately, I haven't had to use it, right? There's potentially, a court could go either way. Equal protection. You can, because that's kind of a weasel word, okay? You can find that there's a distinction between the classes and then make a determination accordingly. The first approach would be obviously through the legislature, and I believe that if you're really sincere being a doctor, you'll stay here and treat us.
Thank you very much. It'll start with Mr. Skupa. unless it's directed at a specific candidate. Ms. Yvonne Taylor, is that correct?
Yes. My question is for all candidates. What is your general judicial philosophy?
Mr. Scotti.
Well, that's a fairly easy question, because you have to be courteous to everybody that comes into court. You have to be prepared, as John has said several times, and I'm always prepared. I'm going to know the law when it's presented to me and know what both sides have said. So you have to be prepared, be courteous, be prepared, and be ready to rule fairly and impartially. You can't show any partiality to any side. You have to apply the law to each set of specific facts. And that's the key. Each set of facts are different. And you have to look at the facts that are there. And sometimes the law works in strange ways, but you have to apply the law to the facts that you've got. And if you can do that fairly and impartially, then you're going to come out with the right legal result. And the other thing you want, of course, is to let all the people know that you want to be fair to each side. That's essential, that they not only feel they got a fair shake, but they actually do get a fair shake.
Mr. Scotti.
Thank you. I appreciate the question. This is the question I like. I'm going to follow the Constitution first and foremost. And I lecture on the Constitution to 5th grade students at Career Day and Constitution Day. I've been doing that for a couple of years, and I'm going to continue doing that. After the Constitution, you follow the law. After that, my general judicial philosophy is that I'm going to vigorously protect individual rights, and I will strictly limit governmental power. And that's going to be my philosophy on the bench. Thank you.
My philosophy always has been and always will be the United States Constitution. That's the organic document that gives us freedom. That's what the military, the soldiers, both male and female, fight to preserve. If we do not preserve that document, we become no less than some of these other third world countries who just cut people's heads off on national TV. I don't know about anybody else, but I noticed some of the judges sitting in the audience here. Everyone knows John Watkins. I never go to court without a Constitution. I use the Constitution. I'm licensed at the United States Supreme Court, had a case accepted at the United States Supreme Court, had my Constitution there. 9th Circuit Court of Appeals, District Court, Justice Court. My Constitution means everything. I will not leave home without it. This is the most important document. This is fairness for all of us, okay? And this document allows some people to be punished accordingly. It works both ways.
Time. Ms. Jefferson.
I think it's a straightforward answer. One, you've got to be courteous and respectful to everybody who's in your courtroom, whether they're the defendant, the prosecution, the attorneys. I think you need to be prepared for every case, on each case, so that you are able to show that you are being fair. But I think, irrespective of my order, I think everybody who comes into the courtroom needs to feel like that they were treated fairly and that they were heard.
Thank you. Thank you very much, candidates. We are actually out of time, and so on the next round, we're going to start from the other end and come this way. I'm sorry, Ms. Knight. We have some strict time constraints. So thank you very much for being here, and we look forward to
Question, can we keep our little cards? I'm going to put it in my office.
Yes, you can keep the paper part.
Thank you.